Your Honor acted as an advocate, effectively, of the applicants on specific occasions, including the hearing of the 1st of July, and in the manner in which Your Honor made decisions to, I was going to say admittedly, but I should say purportedly, made decisions to penalize the respondents at what was purported to be ex parte correspondence, because of what was purported to be ex parte correspondence by the respondents, and in the manner in which Your Honor refused to allow the respondents to agitate applications against the applicant. And then finally the fifth ground is that, this again is an unreasonableness ground, the manner in which the proceeding has been conducted thus far has caused material prejudices to the respondents, and both in terms of the interest in these proceedings, but in terms of the reputation of the respondents, including what was attributed to the respondents by Justice Lee, we would say erroneously and improperly, and I will address that issue as well. So those are the grounds, Your Honor. Can I just confirm the grounds as Your Honor has noted them quickly?
If you like, yes.
Sure. No. Could Your Honor quickly confirm what Your Honor has as the grounds?
Oh, we've made a note. I'm not going to read it out. My associate's been typing as you've been talking. I can't read over his shoulder.
No, it's okay. So the first matter is that we say that the enforcement of our statutory rights was improperly impeded for ideological purposes, or for the purposes of an improper benefit. The second matter was that we say that the conduct of the proceeding betrays an unreasonableness in the arbitrariness with which the decisions have been made, among other things. The third matter is that we say that Your Honor's decisions have been made contrary to the law, the statutory obligations and the common law principles regarding the interpretation of those statutory provisions. That was the third matter. The fourth, just bear with me, yeah. So the fifth matter was that the manner in which Your Honor conducted the proceedings has caused a real prejudice to the respondents, both in terms of their rights in this proceeding, but also their reputational interests. There's a ground that I had previously separated, which I have. It's sort of a moving ground because it is captured by the enforcement of the rights as well, that Your Honor has acted as an advocate for the respondents. That's the fourth ground, but when I'm going into the details of the incidents, I will cover that with the statutory rights part, which is the third ground, and the enforcement of the rights part, which is the first ground. So I simply wish to raise that as a separate account for what it is, but the issues and the rights that will invoke will be covered by the other grounds completely. So I'm going to start with the first matter now. In relation to the first ground, which is the enforcement of the rights, the first issue we wish to raise is that on the 12th of June, when Your Honor advised the parties that Your Honor was taking over the conduct of the two proceedings, parties were invited to provide their submissions and any unfiled material by 2 p.m., the day prior to the date of the hearing. I had written to Your Honor's chambers and clarified that we needed additional time to file the material, and there was no attachment to my correspondence. I had referred to previous correspondence that had been sent in a different proceeding, the related proceeding 642, but that was the extent to which I had made a reference to that particular correspondence, but there was no attachment to my correspondence, and all that was said was simply that the reference to the other correspondence was simply to the extent that the constitutional notice that had been foreshadowed to be filed in the other 642 proceeding would be filed in the current proceeding. All the other matters that were foreshadowed through the correspondence were matters that had been previously raised with the court, the matters being the issues with the bankruptcy notices, in terms of the defects, and that was raised in open court before Justice Bennett. Those matters were also the subject of filed submissions by the parties, by us, by the respondents, so in particular I refer to the outline of issues that we had filed on the 3rd of April, and I refer to the affidavit of Mr. Ansell, which is dated the 17th of April, to which I previously referred. There was a subsequent affidavit that was filed, so the affidavits that were subsequently filed to that particular affidavit were the affidavits of the 16th of June, the 15th of May, that's my affidavit, that was in relation to alleged contempt. There was an affidavit of Ms. Shu that was filed on the 13th of May, which His Honour Justice Lee has struck off the record for irrelevance at this stage, but given us leave to rely on a fresh affidavit in its stead. What His Honour had noted was that there were some parts of the evidence and an amended notice of objection. His Honour said that it would just be convenient for us to file the relevant parts of that affidavit again, but to the extent that the affidavit was on the record at the time, we say that it was open for us to rely on that particular document at the time when the orders were made. There was also an affidavit that Mr. Ansell had affirmed on the 3rd of April. This was an affidavit in relation to the evidence of the covert communication between the VLSB and Justice Gorton. It exhibited correspondence that sought to support an inference that such correspondence had taken place. So that communication was also there. So those were the documents that were already on file, and I emphasize that by way of noting that the material that we had provided to the court was fully captured or substantially captured. This was the material that was provided in subsequent correspondence to the email that I referred. It was captured by the affidavit of the 31st of March and the exhibits to it of Mr. Ansell, the 17th of April, affidavit of Mr. Ansell, the 3rd of April, affidavit of Mr. Ansell, the 13th of May, affidavit of Ms. Shu, and my affidavits of the 15th of May and the 20th of May. So after I had sent that correspondence to Your Honour's chambers, the applicant had responded to Your Honour's request about the filing of material and noted that there was a change of counsel. I had then raised or foreshadowed that it was a matter that the respondents reserved a right to raise issues in respect of, and on that subject I had exhibited some documents to provide notice of the matters that we would raise. So that correspondence was triggered not by Your Honour's request for the provision of documents, and it was not correspondence that would have occurred had the change in counsel not taken place. So it was neither our intention nor our nature that could have led to the provision of that particular correspondence, or the documents exhibited to it, unless the applicant had not written to the court and advised about the change in their practitioners. And the matters that were raised through that correspondence were simply meant to establish a tendency by the applicant in previous proceedings to essentially have multiple counsel represented in proceedings for tactical reasons, where it allows them to essentially feign ignorance to the court in respect of matters that the court has a right to expect the applicant to be aware of. In particular, the matter that had been raised was of a hearing that had taken place on the 17th of March, not long before the hearing before Your Honour on the 17th of June, in which the counsel appearing for the applicant had effectively stated to the court that it was unaware of the making of court orders that had been exhibited in proceedings, in applications that it had participated in, and that had been the subject of court decisions in which those particular orders were referred to. So they had participated in a contested application in which those orders were put into evidence. The orders were also the orders of the magistrate's court, so they carried the presumption of authenticity under the legislation that obliges courts and official bodies to recognize the documents issued by other official bodies of the government. But, essentially, the counsel was a newly appointed counsel, and this has been a pattern in the proceedings. That particular instance in which the conduct had occurred was, in our submission, done tactically, because the applicant wanted to prevent the court from reopening a proceeding, which could only have been reopened following the determination of the proceedings in the magistrate's court. The orders had clarified that the proceeding had been concluded in the magistrate's court, and that proceeding reinstated our right to pursue the applicant in relation to tort law claims for which tactical relief is currently being sought. We say that the reason why the counsel acted ignorantly in front of the court was to prevent the reinstatement of that proceeding until the hearing of their creditor's petition, so it could prevent us from raising that matter as a counterclaim issue. Further evidence in that proceeding clarified that the inference we had drawn was correct. First, they tried to prevent the court from reinstating the matter when the court ruled against them. Then, they said the court should anyway wait, because the hearing of the creditor's petition would be imminently decided. This is to clarify that that was the reason for which we had raised the second correspondence I had raised, and Ms. Shu had added to that. It had nothing to do with the matters that were previously scheduled to be before the court, it was a consequence of what they had raised. We say that, at the very least, a presumption arises that Your Honour is predisposed to drawing adverse inferences about the respondents if Your Honour did not accept the correspondence that we had sent at face value, which was the first correspondence that we had sent to Your Honour, or the second correspondence we had sent to Your Honour, besides the request to extend the deadline for the filing of material in this proceeding. So, in Your Honour's judgment, this is the reason in support of the orders that were published on the 17th of June. Your Honour noted that the respondents had sent ex parte correspondence to Your Honour's chambers and had exhibited voluminous documents. This was in relation to the order that was made in Vid 222. In effect, there were no documents that were sent to Your Honour's chambers. The wording that Your Honour used was that we sent multiple emails to Your Honour's chambers that exhibited voluminous documents. This was in relation to the order that was made in VID 222. In effect, there were no documents that were sent to Your Honour's chambers. The wording that Your Honour used was that we sent multiple emails to Your Honour's chambers that exhibited voluminous documents. I'll refer to the particular paragraph number, I'm just bringing it up. This is Victorian Legal Services Board versus Kuksal, number 2. 2025, 646, FCA 646. So, paragraph 5. I'll start from paragraph 4. On the 11th of June 2025, the matter was reallocated to my docket. I caused this matter to be listed for a case management hearing today, the 17th of June 2025. The parties were requested to provide draft orders and any affidavit material not yet filed by 2 p.m. on the 16th of June 2025. In response to that request, the applicants provided available dates for the hearing of the accredited petition, which were included in the draft order. The respondents did not respond to that request with either a draft order or any affidavit material. Instead, the respondents sent numerous emails to my chambers. We sent one email in response to that request, numerous emails to my chambers, which included various attachments and embedded links. There were no attachments to that email. There were no embedded links to that email. As is my usual practice, I did not have regard to these ex parte communications. I also directed my chamber staff not to open the embedded links in those emails or print out any of the attachments which came with those emails. Now we say that as a matter of fact, the assertion that Your Honor made that Your Honor was unaware of the contents of the emails was demonstrably false, because the assertions that Your Honor made during the hearing on the 17th of June 2025 contradict that assertion. Your Honor had knowledge of matters that were raised in the emails that were sent to Your Honor's chambers in that proceeding and the related proceeding. But more importantly, this is a gross mischaracterization which we say is also dishonest, or so can be inferred from what Your Honor had said during the hearing. I will take Your Honor to the parts of the transcript that cover that in a minute. I also want to point out here that Your Honor starts off by stating that this proceeding was commenced by a creditor's petition, which was accepted for filing on the 28th of February 2025. On the 3rd of April, a registrar of this court made directions concerning affidavit material and submissions and fixed the creditor's petition for hearing at 9:30 a.m. on the 8th of May. On the 8th of May, a registrar vacated the orders and the hearing was transferred. Then there's a number of other matters written. Firstly, the matters are misleading the way they've been put. In particular, in paragraph 2, the proceeding was then allocated to another judge of this court, who was asked to recuse himself on the basis that there was a conflict in his hearing the matter due to another matter that he had been involved in. The judge caused the matter to be reallocated. As Your Honor has conceded this morning, that is factually incorrect, and it colors the way in which Your Honor has presented or introduced the respondents. Your Honor has in the second paragraph referred to the judgment of Justice Bennett. We gather from that Your Honor was aware of all the matters raised in the judgment of Justice Bennett, the one that's cited there, and the hearing that preceded the judgment. Those are the matters that I wish to identify here, in relation to the parts of the transcript that I will refer to now. In respect to the first matter that I had identified, which was the sending of the correspondence or the fact that the assertion was made without a genuine belief in the veracity of that assertion, when I had first raised the matter of the correspondence with Your Honor during the hearing.
Just before you go on, Mr. Kuksal, we've only got until 12.45, so I know you've got 5 things you want to talk about. I'm just letting you know that.
Yes, it will go quicker, thank you.
And if it's the case that Mr. Kuksal is you want to say anything, then you probably only have 1 more hour. It doesn't matter for you which ones you want to focus on, but you don't have to repeat yourself. I'm going to be reading the transcript. No, I'm just saying you don't have to emphasize things or go over things again. I will read the transcript from today carefully, and so, provided you cover your 5 points, that would be helpful to me.
Okay, thank you for that indication. So, I'm not going to read from the transcript then. I'll simply point out what I would like Your Honor to consider in the transcripts, if that's okay.
Yes, please.
Okay. So the first matter is that, when I had first raised the matter of sending when the hearing commenced, I had indicated to Your Honor that the respondents wished to have the court determine some preliminary matters before the hearing of the creditor's petition. Your Honor had indicated a lack of awareness of those issues. I had then indicated that we had sent Your Honor's chambers a copy of the applications that were raised, and I had also sought to indicate, but I was interrupted at the time, that we had also foreshadowed those matters, and that those matters had been previously covered in the proceeding. And Your Honor, at that point, did not say that the correspondence had not been considered, because it had excluded parties to the proceeding. I previously identified that on the 14th of May, Ms. Hsu had written to Justice Bennett. I would like Your Honor to address this, and the reasons that, following the making of that request, Justice Bennett did not include the supporting creditors in all the correspondences that were sent to us. So, there was one set of correspondence that was sent between the parties, and certainly, no complaint was made or matter was raised with us that we should have included the purported supporting creditors from thereon. I know that there were a number of exchanges with Justice Bennett's chambers, exchanges that Her Honor had responded to. So in particular, on the 19th of May, there was a series of emails that were exchanged with Her Honor's chambers, as Your Honor has previously indicated that some of them at least are in the court file. But in particular, for example, I say 19th of May, the email that was sent from Justice Bennett's chambers at 5:15 p.m., attaching a link to the hearing. This is sent to the respondents and the applicant solicitor, and does not include the supporting creditor. This is 19th of May, 2025 at 5:15 p.m. The content of the email is official. Their parties, Her Honor, is content to grant leave to those who have requested. Those permitted to appear remotely may do so using the following details. This is sent by Ms. Ashley Mackenzie, an associate to Justice Bennett. It does not include the supporting creditors. I know that a separate email was sent to them, so they may also attend the hearing. Likewise, previous emails on the chain, for instance at 5 p.m. 19th of May, also did not. This is from Ashley Mackenzie again to us. Their parties, Her Honor, will hear any application in relation to that issue tomorrow. This is in relation to the interlocutory matters that I had raised via email. And throughout that correspondence, which started on the 19th of May at 11:21 p.m., this is the first email that Justice Bennett's chambers had sent to us. 11:21 p.m., the first time the email was sent, it had excluded the supporting creditors. Now this is relevant in two respects. One, that we had a legitimate expectation that the court would be at the very least aware, or before making an allegation of a series, as something that can be interpreted to be a contempt of court. Ex parte communication, I note, it can be grounds for a finding of contempt of court. And I think it's a self-evident matter. But to the extent that some people would seek to challenge that, I rely on Re JRL, Ex parte CJL 1986, 66, ALR 239, and the authorities cited therein in relation to influencing judges through ex parte correspondence being a serious contempt of court. So in particular, the authority of Kanda versus Government of Malaya was cited there, which is a fairly well-known authority. So that was the first matter, the legitimate expectation issue. The second issue is that we say that the emphasis that Your Honor placed on the ex parte communication point was such that it implied the contravention of an uncontroversial and universally accepted norm of communication, such that the conduct of breaching that norm disentitled the respondents from having their matters considered by the court. So, firstly, we say that if that had happened, it would have been an overreaction for the court to simply ignore our correspondence. The appropriate course of conduct would have been, because to do that was to conclude that the conduct was engaged in nefariously. If Your Honor did not draw an adverse inference from the act, then the normal or expected course of conduct would have been for Your Honor to include the parties that we had excluded, and simply say, "You forgot to include these, and this should not happen again." Now we've been in multiple proceedings, including with the applicants, and where other parties have missed including one of the parties, that is the course that the court has adopted. To essentially not hear the respondents, which is what happened, and only hear the applicants, was incompatible with Your Honor's obligations in relation to the exercise of judicial power, and it was incompatible with what was said in Condon versus Pompano about the way in which judicial power can be exercised by the court. That's the first matter. The second matter is that we say that if the act of excluding the purported supporting creditors was in fact that egregious, then Justice Bennett would have reacted similarly when we first excluded them, and said that they should not be included anymore, or at least if the supporting creditors had a right to be included in the correspondence, Justice Bennett would have at least given them an opportunity to be heard before accepting that they should be excluded. And I pointed to a communication chain that originated from Her Honor's chambers on the 19th of May that itself excluded the supporting creditors. The correspondence, which is again part of the public record, will show that the supporting creditors were not heard before they were excluded, and our request was simply accepted. So if it had been a matter as egregious, then there is a wide chasm that separates the way in which Justice Bennett has dealt with the matter and Your Honor has. So we say that that again is incompatible with an honest account of things. And as I've noted, it's also inconsistent with the reason that Your Honor had given me during the hearing for why Your Honor had not considered the matter. We say that the reason why Your Honor misrepresented the matter in the judgment was because Your Honor had to find some justification for not going through our correspondence. And the way Your Honor justified not being aware of our correspondence was by effectively destroying our reputation and vilifying us by two measures. 1. By perpetuating a slanderous allegation that has been previously made against us about improperly sending voluminous documents or relying on voluminous documents that may be irrelevant, that Justice Gorton has improperly sought to perpetuate. And the second being, well, the second was an original one, that we have improperly communicated in an ex parte manner. Now, why this was significant is that firstly, the correspondence with Your Honour's chambers had foreshadowed the tendency of the VLSB to use counsel to mislead the court. And I note that when I had requested Your Honour for reasons for the decision that was made on the 17th of June, I had particularly requested Your Honour to address the matter of why Your Honour did not let me raise a complaint against the counsel acting for the other side, Ms. April, in relation to her misleading the court about a matter that she could have easily verified through the transcript. The matter being that Judicial Registrar Ellis had predetermined our Honour freer or else not predetermined so much, but already determined our application to issue subpoena, which was a completely false assertion that could have easily been avoided if she had referred to the transcript. And I say that the barrister conduct rules had precluded her from raising that factual matter. Without actually checking the transcript on account of her duty of diligence, she was seeking to prevent us from obtaining critical documents, evidence in this proceeding that could help us by relying upon a factual assertion that was completely false, and she had a duty to confirm that that had taken place before preventing us from what is our substantive right to a fair hearing. So we say that the matters that we had raised via correspondence in foreshadowing that one, that Your Honour, to say that this is not a commission of inquiry into the conduct of the counsel engaged by the applicants. We say that it would be, again, an overreaction to assert that if Your Honour had not apprised herself of the matters that had been raised in the correspondence, it would be odd for Your Honour to simply say that this is not a commission of inquiry to us because we asserted for the first time ever that the counsel for the applicant had sought to deliberately mislead the court. And I note that Miss April at no point apologized to the court or to us for raising a factually inaccurate submission. She never acknowledged it, even though by conduct she conceded it, which we say is indicative of a contumelious disregard for our rights and confidence in the court, overlooking that contumelious disregard. So those were the matters that we say had motivated. Your Honour, we draw an inference too. Well, Mr. Ansell and I draw an inference. Miss says a reasonable apprehension can be drawn to make those assertions. And I just want to refer to the particular email that I had sent, requesting for the reasons. And this is the email that was sent on the 17th of June. And so, the time at which this was sent is 11:33 a.m. This is an email from me. It was referred to in the judgment actually. It was referred to in paragraph 11. And I also note that right after the hearing at 10:46 a.m., again contrary to what is indicated in paragraph 11 of the judgment. So paragraph 11 of the judgment indicates that when Your Honour returned to chambers, Your Honour found that we had sent correspondence to the chambers, whereas what had actually occurred is that after the hearing, Your Honour first sent correspondence to us, or the chambers did. And it is reasonable for us to draw an inference that it was at the instructions of Your Honour. This is from Ms. Lauren Gunter, 10:46 a.m., and it says, "Please be advised that the orders made in the morning's hearing are now available. The parties are reminded of 3 matters. Justice Downs does not read emails that are sent to this email address, full stop. If the parties wish to adduce evidence or make submissions, then that should not occur by email. This is completely contrary to, it contradicts the matters that Your Honour has recorded in her own judgment, that Your Honour had invited the provision of unfiled material. So, we say that this also indicates that Your Honour simply didn't want to hear from us. And because this was an unusual and improper way of conducting the matter, Your Honour manufactured a legitimate reason to prevent us from or to justify not reading our emails, which was that we were sending them ex parte. It also says that documents which are sent to this email are not filed in court, and then parties are prohibited from recording the hearings. So we say that that is a serious matter, and it's a matter that is not simply a matter of innocent misrepresentation. It's a matter that goes to preventing us from enforcing our rights, and also acting as their advocate, because Your Honour is, through the conduct, is simply attributing the delay in the conduct of the proceedings to us. Now this is relevant also because, Your Honour, on the 3rd of April, the respondents had made an application for the matter to be referred to a judge. This was before Judicial Registrar Ellis. These matters are caught in considerable detail in the affidavit of Mr. Ansell. By the way, it was read into evidence on the 15th of May, when it was relied upon before Justice Bennett, and no objection was taken to that affidavit. For Mr. Mukherjee's benefit, I said that. So in that affidavit, Mr. Ansell details how I had repeatedly made applications for the matter to be referred to a judge. The correspondence with Judicial Registrar Ellis, Chambers also confirms that we had repeatedly requested that, and then sought confirmation that Her Honour would act in accordance with her obligations under the Federal Court Act and rules, and refer the matter. It was only after I threatened to make an application against the counsel and the solicitors for the other party, if they did not. So Judicial Registrar Ellis was seeking their consent, the applicant's consent, before referring the matter to a judge, which, again, is very problematic given the judicial obligation to especially maintain a distant relationship with the executive in proceedings involving the state. And in this respect, I refer to Nasmith v. McGovern, 19539, OCLR 336. Among other things, it's also pointed out that it is a requirement under the Judiciary Act to treat both parties equally when the state is involved. And then, I also refer to the content of Section 55ZF and the adjoining provisions of the Judiciary Act, which clarify an intention to hold the executive to a higher standard than regular litigants. And also I rely on the authority of R v. Tuahi, to which I previously referred, and Enfield v. the Planning Commission Corporation of the City, Enfield v. Development Assessment Commission, 200169 ALR 400. It sets out the court's obligation to use both its statutory and equitable jurisdiction to provide relief against government bodies in creative ways. So, we say that the conduct was completely contrary to that Judicial Registrar Ellis and Your Honours. And it was only after I threatened the applicant in relation to their non-provision of consent, that they responded to Judicial Registrar Ellis, close to the end of business, and said that their consent is irrelevant. This is Mr. Heath, Gerald Heath. Now, the implication of that was that, because this was done a day before the hearing, on the 7th of May, firstly the matter could not be allocated to a judge by then. If on the 3rd of April the matter had been allocated to a judge, we wouldn't have an adjournment on the 8th of May. The matter would simply go to the judge. We had no reason to suspect that the judge would not issue a subpoena, as we were requesting. Our expectation was, we wanted a judge to hear the matter, because then, the first opportunity we would get, they would, in our view, either require the VLSB to produce the document or issue a subpoena, and that would have essentially ended the case as far as we were concerned, because it would have demonstrated that Justice Gorton made orders at a time when he was disqualified from presiding over the proceedings because of his communication with the VLSB. The allegation against His Honor is that he was a complainant in the investigations which were sought to be judicially reviewed before him. He has stated during the hearing on the 5th of December 2023 that particular transcript is exhibited to the affidavit of Mr. Ansell, that he did not think that if that had occurred, he would be disqualified from presiding over the matter. The fact that if he had private clandestine correspondence with the VLSB about the issues that were raised in the proceeding before him, he did not think that would disqualify him, and His Honor said a number of other highly troubling things which are caught in the affidavit that I have affirmed this morning. He said. So the point is that if the applicant had not prevented, or had performed its duty, as a model litigant, and a statutory body, and under Section 37M or N, of the Federal Code Act, to conduct the proceeding responsibly, then the matter would not have to wait until the 7th of May.
Mr. Kuksal, I don't mean to interrupt you, but you're sort of heading off the track a bit. We're doing a recusal application in relation to me.
Yes, I am getting to that, Your Honor.
Justice Gorton, the board, Registrar Ellis, while these facts are interesting, they don't really bear on the application about me, do they?
Yes, Your Honor, they do. They directly do, and I'm getting to that in a moment. I just want to point out one more thing. Justice Bennett was only appointed to this matter because she was the duty judge the following week. So this was on Friday that they had sent the correspondence, and then that when they conceded that they could not withhold consent to stop Judicial Registrar from referring the matter to a judge, in the same communication, they said that the matter should be referred to the duty judge. That correspondence was sent after hours on Friday. The duty judge on Monday was Justice Bennett. This matter went to Justice Bennett because of what they had done. Now this is relevant because in Your Honour's reasons, Your Honour cited paragraph 13, Australia and New Zealand Bank v. James, 2011, FCA 768. Your Honour first sought to create a narrative that this proceeding has had a number of judges and procedural delays, then relied on an authority where the respondents had been responsible for a bunch of procedural delays. In that case, there is no comparison between the delays that have occurred in this matter, and had occurred in that matter, and what the respondents were seeking in that matter. But the principle that Your Honour used this authority for is a very straightforward principle, but this is an exceptional authority. This is an exceptional authority. It's an exceptional authority in that the conduct of the respondents was particularly egregious. And this is a very notorious set of disputes. There were multiple interrelated, and in that way there may be some similarity between the matters, but not in the context in which Your Honour, in the sense that we have had a range of proceedings against the Legal Services Board, but not in the context in which Your Honour raised this matter. In fact, Your Honours, the way in which Your Honour dealt with our applications is contrary to the way the court had dealt with the respondents in that particular proceeding. We say that Your Honour created a narrative that we have caused the recusal of multiple judges, and then we are exhibiting the same conduct with Your Honour. And this has already caused so many delays, and therefore the court has been very strict with us. Now, I refer Your Honor to the authority of expense reduction analysts, Group Pty Limited versus Armstrong Strategic Management and Marketing, Pty Limited, 2013 HCA 46. What the High Court decided there was that the court had a responsibility, when there is a delay, to attribute the cause of the delay to the right party, and not simply prejudice parties that are not responsible for the delay, and that it is not that the court should be averse to all interlocutory applications to the same extent. The responsibility is to see which is made properly and which is not, and then I also emphasize Krakow versus R. 1998, HCA 43. The ultimate pursuit of the court's jurisdiction is for the natural justice, and all other matters are subservient to that. The procedural norms, they do not displace the duty to do justice in the matter, and in that respect, I also emphasize Paino versus Hofbauer, PAINO versus HOFBAUER, 198813 NC, LR 193. So these authorities essentially reinforce the self-evident principle that the court ultimately has to do justice. And the jurisdiction to refuse to hear a party or to deny them applications that are open to them to make is a jurisdiction that is reserved under the court's duty to prevent an abuse of the court process. And there are factual findings that are necessary that need to be necessarily made before that jurisdiction can be invoked. It's not a jurisdiction that the court can simply exercise without the determination of a proactive fault element by one of the parties. And in that respect, I also refer the court to Wandsworth London Borough Council versus Winder, WINDER 1985 ACA 461. What was said in that authority was that, for brief context, in that authority, what had happened is the council had sought to enforce certain penalties against some parties, and the matter was subject of litigation in a particular court. The persons whose interests were being prejudiced by what they considered to be a jurisdictional decision made in jurisdictional excess, then started collateral proceedings in the higher court. And they were sought to be dismissed by the government, the statutory body, as an abuse of the court process. And the court clarified in that authority that when members of the public pursue measures to contain the executive, that the law entitles them to pursue, it cannot be an abuser process by definition, because they're constrained by the law that the government sets, and they have a rational interest in getting rid of what they consider to be decisions made in jurisdictional excess, but also they have an obligation in relation to their obligations to other parties. In RV Toohey, ex parte Northern Land Council, to which I've previously referred, it was said by the court that the court used rather strong words. They said something that conveyed their strong objection to the notion that applicants, litigants, members of the public raising collateral proceedings against executive bodies, that particular matter in itself could clog the courts, that those applications serve an important purpose of 1. Reinforcing human rights, which is an entitlement that the parties that are raising those issues have, and 2. They seek to check the executive from generally engaging in that conduct, thereby preventing the need for those cases later on. What the court said was, if the public is generally proactive in challenging the decisions of the executive through proceedings, then it reduces the tendency to engage in conduct that may cause those proceedings to occur in the first place, and that in any event, there is no alternative. Parties who consider the government to be acting unlawfully do not accept that the government has acted lawfully just because the courts prevent them from raising those matters. And it just leads to a festering of those issues, and ultimately it's a threat to law and order. Those were the matters that R versus Toohey had emphasized. So we say that in particular, Your Honor implied through the reasons that the applications that were sought to be made on the 17th of June were applications that had been made without notice to the other parties. They were applications that, it was implicit in the reasons that they were applications that may prejudice the rights of the other party, that we did not have an automatic entitlement to raise, that the court must first consider whether or not it is appropriate to raise those applications. And then it was emphasized that the substance of those applications was not being determined, only the fact that the court should hear them before the conclusion of the proceeding. Now we say that that was an irrational way of reasoning, because interlocutory applications by definition must be decided before the conclusion of the final matter. Secondly, besides the definition, the purpose of raising those interlocutory matters was to attain a benefit before the creditor's petition is actually heard. So it would be counterintuitive and completely senseless for those matters to be heard afterward. And in particular, Your Honor did not identify the application, the orders that were sought through the application. It was referred to in the abstract. And we say that was also because it would have been impossible to refer to the particular matters in that way if those matters were identified. Specifically, the first matter, not necessarily in chronological order as they were put, but one of the matters that were raised through the interlocutory application was an order seeking the issuing of a subpoena to the Legal Services Board.
Sorry, Mr. Kuksal, so why is this relevant to the recusal application? Are you going to rehearse what you said in front of Justice Lee?
I don't know whether I said that before.
No, I'm just conscious that you've got about 22 minutes.
So this is relevant.
I want to make sure I understand all the arguments, that's all.
So we're saying that the court prevented us from enforcing our statutory right to issue a subpoena.
Right. Well, I didn't do that. How is that relevant to the recusal application?
You did that, Your Honor, is the assertion that we're making. And I will get to how Your Honor did that. We're relying on the principle of constructive failure to exercise jurisdiction. So when Your Honor refuses to hear an application that we're entitled to raise, then Your Honor is implicitly rejecting the application. That's the principle of constructive failure to exercise jurisdiction. I'd like to cite some authorities in support of that. So there's Plaintiff 1572002 versus Commonwealth 2003, 211 CLR 476. There's also Minister of Immigration versus .li, that's 2013 HCA 18. There's Jiang Shengli versus Refugee Review Tribunal 199436, all 273. And then there's Aussie Airlines Pty Limited versus Australian Airlines Limited and others. The citation is 1996 139 ALR 663. And one other authority. This is Rediffusion versus Attorney General of Hong Kong 1970 AC 1136. In particular, what was said here is that when the court refuses to exercise a discretionary jurisdiction like giving a declaration, the court is not refraining from exercising the jurisdiction. It is determining that it is inappropriate to exercise that jurisdiction at the time and therefore determining the substance of the matter. We say that it is a substantive right to seek relevant documents in a proceeding both under the common law tradition and under the Evidence Act, and the Charter of Rights and International Covenant on Civil and Political Rights. So the rules of the court state that we do not need to put the other party on notice of the application to issue a subpoena, that the application can be raised during any hearing. There's no advance notice that's required, it can be raised orally. Those are the entitlements that we have under the federal court rules. And I had agitated those matters on the day. We say that Your Honor firstly constructively dismissed our application to issue the subpoena by refusing to make the order. And secondly, we say that Your Honor effectively refused to mention that matter or failed to mention that matter in the reasons, because it would have pointed out it would have been contrary to the objective of creating a narrative against the respondents. And we say that Justice Lee was affected by that narrative. His Honor had notably not been aware of all the documents that have been filed in the proceeding. And we say that it is that narrative that colors the introduction to the plaintiffs or the respondents in this case to other parties, including our judicial officers. And we note that the matter of contempt had been exhaustively covered, canvassed before Justice Bennett. In fact, Your Honor's reasons also indicated that one of the reasons she was recusing herself was because one of her former clients may be a witness in the contempt application. So to say that we had ambushed the other side by raising the matter of contempt without prior notice is to basically vilify us. And we say for the purpose of denying us our statutory right. Now, in relation to Justice Lee and his decision to not, the decision His Honor made, in relation to stopping us from issuing subpoenas until the notice of objection has been clarified, I note this. His Honor came into the proceeding abruptly. His Honor had Your Honor's judgment in front of him. His Honor noted in the reasons that he was disadvantaged by the fact that he hadn't read the affidavits or been taken to the affidavits filed in the matter, which Your Honor, we say from all the material that we have referred to earlier, would have been aware of. His Honor notably was brought for a specific matter. But we also note that when we had first raised with His Honor that we wanted to issue a subpoena by writing to His Honor's chambers, which is the second way to issue a subpoena, His Honor had noted that we could simply issue a notice to produce a fact that Your Honor did not do. The second matter is that the only reason why His Honor prevented us from issuing a subpoena was because His Honor was unaware of the way in which the grounds were argued, specifically the fifth ground for the objection. And one way in which His Honor is mistaken in the reasons, is that His Honor implies that we had. It's a very subtle point, but the way His Honor puts it is that we had taken His Honor to the grounds and the grounds were a sufficient account of the matters that we wanted to rely on in objection. Now Your Honor will note from the transcript that His Honor had continuously prevented me from raising matters because he wanted to cover a number of things in the same proceeding. So the whole thing was rushed. There was no opportunity for us to raise matters in detail, but it has always been our position that the grounds as they are framed are wide enough to allow us to rely on the evidence. We noted to His Honor, and this is not a controversial point between the parties, the matters on which we rely in relation to the documents that we seek. They came to our attention following the drafting and filing of the Notice of Objection, which is why His Honor gave us leave to file the Notice of Objection, because we only discovered or rather we only obtained more substantive evidence which allowed us to narrow down the time during which the correspondence had occurred between the parties, so as to seek a precisely worded subpoena in April, and then it was further confirmed in May. So in February, when the Notice of Objection was drafted and filed, it did not include those matters, and His Honor did not hear us about the evidence that we had already filed that indicated all of this, and that is why His Honor gave us leave. But I also rely on Macquarie Bank Limited versus National Mutual Life Association of Australia Limited 1996, 40 NSW LR 543, and I rely on Waterboard versus Mistakers, MOUSTAKAS 1988 HCA 12, along with Wiesenbeek versus Australasian Marine Imports, Pty Limited, 2017 FCA 18, and Bank, BAMQUE, Commercial COMMERCIA 11, for the proposition that even new matters can be introduced through evidence, and if they are sufficiently raised through evidence, the court actually determines the case based on the evidence before it, and not on the basis of the pleadings. Pleadings are simply a tool that assists the court, but it does not confine the issues raised in the proceeding. Now His Honor did not give us an opportunity to raise any of those matters that day, as the transcript will note, because of which His Honor, to basically compensate, gave us leave to file a Notice of Objection. Then His Honor sought from us a date by which we can file it before the hearing. We said we could not file it before the hearing, and His Honor noted that in his reasons, and he said that we simply have to file it then. He did not, so he gave us open leave to file an amended Notice of Objection, and said that this is a matter that we need to cover with the docket judge in due course. So that's what we say. We were prejudiced before Justice Lee, because of the way in which Your Honor had put the reasons. This goes to the fifth round, and it will go to the further conduct of the proceedings in a minute that I will go to. These matters cover the first round. They cover the second round, in the sense that the misrepresentations, or the arbitrariness with which, first we were asked to send the orders, and then those representations were effectively disowned, indicates that there wasn't a consistent principle underpinning those assertions. And then, the other matter is that this was not the only instance in which this had been done. In 642, we had provided Your Honor's chambers with the proposed orders that we had sought. So we had sought, essentially, and we had done that prior to the respondents addressing the court. We had done that on the 16th of June. This was through a correspondence of Ms. Dew, and I note that the correspondence is dated 16th of June 2025 at 1:02. And in that, we had raised with Your Honor that we needed 1.5 days for the listing. We wanted the listing to take place as soon as possible. 13th of June was the preferable date, and we wanted to cross-examine Mr. Heath and also adduce evidence. Then on the 19th of June, the applicant responded to Your Honor and said that, basically, it was preferable that the matter be heard on the 18th, or the 21st of July, and half-a-day hearing, and so on. Then, when Your Honor made a decision on the matter on the 20th of June, Your Honor basically gave them everything that they had asked, without addressing why we were not being given any of the things that we were seeking. So relevantly, through the correspondence on the 16th of June, we had noted that the court was bringing the administration of justice into disrepute by extending open-endedly suppression orders that the Federal Court Act prohibited the court from making, and it was unconstitutional, and it was meant to, and was having the effect of prejudicing us in respect of other court proceedings. Logistically, by preventing us from uploading documents, serving documents and so on, Justice Lee found those applications to be ill-conceived. Now this is not in the judgment, but Your Honor will find this in the transcript. His Honor had some very strong. So Your Honor will note from the transcript that His Honor noted that it was unorthodox and inexplicable for a regulator to bring that proceeding. His Honor noted that essentially, there is no basis in law for parties to be gagged, and it was completely improper to raise a separate proceeding to preemptively prevent the filing of evidence. And then, even if those matters were to be raised, the rules of the court required the matters to be raised in the same proceeding. Now we say that the matters were raised separately because they are bringing lawyers weekly into every hearing in this proceeding, and that's why they wanted the matters to be raised separately. In this respect, if I may just get 10 seconds to confirm with Ms. Gurju if she has sent the lawyers' weekly articles.
I've got the articles, Mr. Kuksal, but I'm just conscious that you've got 5 more minutes, so.
Your Honor, I'm going to need a little bit more time.
Well, I've got another matter this afternoon. I can give you until 1 o'clock, but I need to take a short break. But before we get to that, Did you say you were going to file some submissions to do with moving the creditor's petition date? Is that what you said to me at the start of the hearing?
Yes.
When can you provide those?
Imminently. So part of those submissions.
Oh, terrific.
What was that?
Keep going.
Part of those submissions, by the way, Your Honor, they're captured in the correspondence to Justice Bennett's chambers on the 16th of May. So basically what we were going to provide to the court was a copy of that with a list of authorities about they go to the abuse of process, allegations, how they can be properly abused the process through the bankruptcy jurisdiction of the court, those allegations, how they can be properly raised, what the court's obligations are when those matters are raised. So those matters were raised on the 16th of May with Her Honor, and we had provided Her Honor with a copy of the submissions that both sides had made before the High Court in Ramsey Healthcare, which basically showed that both sides had conceded what the principle was. And the essence of the matter that was raised before the High Court, and the High Court also affirmed this principle, was that, in order for the party to successfully invoke the court's obligation to go behind the judgment date, all that had to be done was essentially, the matter had to be pleaded, that there had been a failure of the legal process in the proceeding, in which the orders giving rise to the bankruptcy notices were made. This was said by Chief Justice Kiefel at the time, Justices Keene and Nettle at 94th in Ramsey, and I will request the court to review the correspondence that was sent to Justice Bennett's chambers on the 16th of May. This was sent at 6:50 in the morning by Mrs. Q.
So are these your submissions that you're talking about?
Yes, so these were submissions, they're not filed with the court. They were by way of correspondence. So what happened on the 15th of May was that, in deciding whether or not the recusal should be granted, Her Honor was considering the scope of matters she would have to decide who could be the witnesses that she would have to decide. So she may have to decide the credibility of. And there was a disagreement between the parties about how easily they whether or not the respondents had access to, or whether or not the respondents had a right to require the court to go behind the judgment bet. So because no authorities had been brought to Her Honor's attention at the time, through correspondence on the 16th of May, we brought the authorities in that respect to Her Honor's attention. And we also attached the submissions that had been filed and considered by the court already. So those were the matters. Yes, Your Honor, definitely, 16th of May, the email that was sent with the attachment? With the attachment. Yes.
And also you sent a list of authorities.
Yes, we will send that imminently. I believe that Miss Chu has already sent the affidavit as well, my affidavit of this morning, which I will rely on in relation to the second matter. And essentially His Honor has given us leave to file the amended notice of objection, which we will file today. But I wanted to raise this to Your Honor's attention, this affidavit, because this affidavit it contains the basis of the grounds that will be relied on for the notice of objection. And this is just so Your Honor could have an indication of those things in exercising the discretion to consider those matters. So this affidavit was made for the Supreme Court. There's a title in the title of the document. It says it's an affidavit of Mr. Flitner, but it's actually my affidavit. I'd like to correct that. It was affirmed this morning. It hasn't been filed yet, obviously, but I drafted the content of it, and the cover was taken from a different affidavit by a member of my staff this morning. So, that's a typographical error, obviously, but it says that it was prepared by me, and where the giraffe is it says that I have sworn it, and there are my signatures everywhere. So, that sets out the evidentiary basis. It summarizes the evidentiary basis upon which we are particularizing the grounds in the notice of objection. This will be the revised corrected affidavit will be filed in the Supreme Court today, in support of this application, and will be exhibited to the affidavit that we filed in the federal court, in support of the notice of objection.
I understand that, but I thought there was paragraph 2 of your application before me. So if I go through the process of working through your submissions about the recusal and I recuse myself, that's it. But if I don't recuse myself, I then have to go on to consider paragraph 2.
That's right.
What do you rely upon for that? Okay, you said there were some submissions sent through to Justice Bennett.
Yes, and I'll get to that in 1 minute. I want to complete the first element. There's not much left, and I want to make sure that I've captured.
Okay, that's all right. All right.
So with respect to the first order, besides the matters that have been raised, we say that if Your Honor had actually heard the subpoena matter in accordance with our right, and indicated one way or the other, whether the court was open to issuing the subpoena, or whether the court wanted us to particularize the matters in the notice of objection, then that matter would have been dealt with on the 17th of June itself. The other matter is that, as I was saying, Your Honor failed to consider our application or the orders that we had sought on the 16th of June in relation to the 614 proceeding. And we say that it is evident that from what Your Honor said, that Your Honor's schedule did not permit Your Honor to expeditiously allocate time or immediately allocate time to both proceedings. But it is clear that Your Honor prioritized the bankruptcy proceeding over the 642 proceeding from the conduct of Your Honor. And we say that Your Honor had a constitutional obligation to determine the matter, the 642 matter first, and also Justice Maher had explicitly made orders that the matter be dealt with urgently. So 1. Your Honor did not prioritize the bankruptcy matter in the sense that the directions hearing was heard in this one first. 2. When we requested the court to schedule the hearing of the matter urgently, then the court essentially delayed the thing at the request of the respondents, even though no one had filed a constitutional notice. And, in fact, we had indicated on the 16th of June that we're not filing a constitutional notice in that proceeding, specifically to prevent it from being delayed. Because if we had filed a constitutional notice, then the court would have had to give the Attorney General time to respond. And we did not want that matter to be delayed. So, in complete transparency, we had indicated to the court that we were not doing it, even though we considered the issues to arise, and that was in fairness to the applicant. So they could file a constitutional notice in that proceeding if they wanted to, but what they did was not file the constitutional notice themselves but improperly delay the matter, and the court, we say, allowed them to do it. And that was improper. Then the other matter that I wish to raise, and this is something that I had agitated on the 1st of July, is that we say that based on the matters that Your Honor was privy to by correspondence and the submissions raised before Your Honor, albeit limited, it was evident that the proceeding was completely hopeless. The other proceeding, 602, there was no prospect that they could succeed on that proceeding, even their own authorities went against them. There are no authorities that could go in favor of them. And then, in those circumstances, when Your Honor implied that I may be breaching that order on the 1st of July, Your Honor indicated that on the face of it, I was prevented from raising those matters in any proceeding. In fact, though Justice Lee did not go as far as setting the orders aside, His Honor, throughout the hearing on the 8th of July, essentially noted that the orders were ambiguous. They were hard to follow. And then, basically, His Honor stated all the things that I had said to Justice Maher during the hearing on the 8th of July, all the things. And in fact, what His Honor did was he struck off the only paragraphs of Mr. Heath's affidavit that could have been the basis for the making of the injunction. So the paragraphs that His Honor struck off of Mr. Heath's affidavit, this is not in the judgment, and it's something that we have a complaint about, that His Honor failed to include this in the judgment. But, in the interest of time, I'm not raising those complaints with Your Honor. But I think it will be helpful for Your Honor to know this.
Well, I'm not sure it will be, Mr. Kuksal, because I think we need to focus on your arguments about me, not about another judge.
It is about Your Honor in the sense that the second order will also address this momentarily. But the affidavit, how much longer are you going to be, Mr. Kuksal? Your Honor, I'm endeavoring.
It's been set down for half a day, and technically it's supposed to finish at 12:45.
Yes, Your Honor, but in the interim,
I haven't been able to get an idea about what submissions they wish to make about paragraph 2 of the application, about adjourning the creditor's petition, if they want the opportunity to put on written submissions as well.
Your Honor,
I need to hear from them.
Irrespectively, in the interim there have been developments which have caused the matter to expand beyond what we had originally anticipated. But
That doesn't matter, I'm stopping at 1 o'clock, Mr. Kuksal. So if you want, you can talk about Justice Lee and what he did wrong, that's fine.
No, I'm not talking about that, Your Honor.
To the application,
I'm not talking about that at all. I'm talking about what is relevant for Your Honor right now. And I say that what was struck off was paragraphs 31 and 32 of the affidavit of Mr. Heath, and paragraphs like 34 and 35 and a number of other paragraphs were essentially reduced, or there were constraints put on them in relation to the matters about which they can be relied upon. Now, that and during the cross-examination, there was an important revelation that was made by Mr. Heath, which basically was an affirmation of the matter that he has raised in paragraph 5 of his, in paragraph 10 of his affidavit, and in paragraph...
I'll just stop you there for a moment. Does the Victorian Legal Services Board want to put on submissions about an adjournment of the creditor's petition?
I anticipate we would, Your Honor.
I'm just trying to read Mr. Kuksal's affidavit of today to understand on what basis it is sought. Alright, let's not try and do it on the run. Does the board want an opportunity to put submissions on?
Yes, Your Honor.
So, when will you be able to do those, or is it a case of waiting to?
We would seek to do it as soon as possible in the usual course, but
I don't need lengthy submissions, so if they're done by close of business tomorrow, that would be appreciated.
yes, I'm sure we can manage that.
And I'll be delivering my judgment on the recusal application on Monday.
Okay. So, Your Honor, to clarify the matters that have occurred in the interim which bear on this further, is that, firstly, His Honor struck out the only 2 paragraphs on which Justice Maher had relied to grant them the interim application. Now, we are seeking costs in 642, not costs as in legal costs, but the order was made under an effective undertaking that all our economic losses and any economic cost that is incurred by us will be.
That's not relevant to the recusal application.
No, it's relevant to Order 2, Your Honor. It's relevant to Order 2.
How is it relevant to Order 2?
Because we are seeking substantial reimbursements in relation to their undertaking in 642. That is a matter that the court has an obligation to deal with expeditiously, and it is a matter that goes to the counterclaim that we have against them. And in any way, if the court were to proceed, the court would have to decide that matter in the other proceeding. So it would be completely improper for that matter to go on without the determined.
For which matter to go on, sorry?
The hearing of the creditor's petition. The hearing of the creditor's petition without a determination on what should be compensated to us, for an abuse of the court's equitable jurisdiction. I raise that matter because the only paragraphs in which they had relied to get the order were struck off by Justice Lee. And what His Honor had said is that even if they were not taken out for hearsay, they would be taken out again under Section 135 of the Evidence Act, because they were unfairly prejudicial. Now, Justice Maher, I had already raised those matters before Justice Maher, but also, Her Honor had not even finished hearing my objections as Her Honor noted. Now it's because the court delayed the hearing of the matter, and in that we say, Your Honor is implicated in the way Your Honor prioritized the matters. We were prejudiced because if the determination of relevance is an evaluative judgment, it's not a matter of discretion. There are very few circumstances in which reasonable minds can differ. In all seriousness, if the court had heard the matter and decided the matter according to the law, that application would have been dismissed immediately. We would have had our claim satisfied earlier. We wouldn't be in this matter. The second issue is that because of the matter going to a new judge who did not know about the notice of grounds and how they were pleaded, the subpoena or notice to produce could not be decided. And because of that, we've been given leave to raise the fresh notice of objection. We seek to rely on that entitlement that has been given to us. The third matter is that we say that His Honor partly misunderstood and partly was unaware of the basis on which the separate determinations were to be decided, and therefore His Honor has dismissed that part of the proceeding. We note that the court had already decided that the separate determinations will be determined before the hearing by consent of both parties, because the original submissions were about whether or not it should be heard beforehand. His Honor did not understand that. He didn't clarify that. He rushed the matter through. Though the court had made a consent order effectively, His Honor misunderstood what had happened, and he thought that the court was deciding whether or not to hear the separate determination first, which is what Your Honor had originally planned, but then decided to go against that because the applicant had consented. Now we say that the applicant had a responsibility to clarify that to Justice Lee, and they did not. And we have a legitimate expectation that orders that we had earned from the court by their concession, they cannot be vacated without any basis. His Honor did not determine the merit of those issues, save to the extent that the issues in relation to the suppression order, His Honor determined in our favor. The comments His Honor made notably were about the notice of constitutional notice that had not been accepted for filing. He did not make any comments about this. His Honor also did not determine our application for compensation in this proceeding, which was before him, but he didn't have time, and he didn't even, we would never heard about that. It was never considered. His Honor simply dismissed it because I think he overlooked it. It's not addressed in his reasons either. He didn't address the application about the contempt, whether or not the fee is payable. That's another matter that will now be before the court, because the court had scheduled a determination of that, which we had earned. The other matter that is relevant is that His Honor has given us leave to file the contempt charge and affidavits in support, and it was heard before His Honor that that application had to be heard beforehand. The rules require it. The authorities require it. We're alleging that Mr. Flitner is continuing to be harassed. He's made a fresh affidavit in this proceeding, which we will file and seek the court's leave to rely on in this proceeding, in support of the contempt charges and in the bankruptcy matter. What His Honor has done effectively is required us to seek the court's leave before the Flitner allegations can be introduced. Now, that matter will need to be determined before the hearing well in advance, because we will seek to call Mr. Flitner to give evidence in court. And the other matter is that we seek to call witnesses from the Legal Services Board through subpoena, which can only be filed after the notice of objection grounds are clarified.
That's coming today, Mr. Kuksal, isn't it? The amended notice is coming today?
We can file the amended notice of objection today, yes, but Your Honor has to first decide the recusal application.
Well, no, you should file your documents today, not hold off until I give judgment in the recusal application.
No, I accept that, and that's what our plan is. But the one complication there, Your Honor, is that His Honor has made orders for the court to first hear us about filing the Flitner allegations in this proceeding again after the notice of objection has been reformulated. The whole point of reformulating the notice of objection was 2 reasons. 1. Subpoena. 2. To show how the Flitner allegations would be relevant to the case that we're making. So we will lodge the file, the new affidavit that Mr. Flitner, I say new, but he had never affirmed an affidavit for this proceeding, but he has now affirmed an affidavit for this proceeding, and it confirms that the intimidation of which we complained continues.
Before you go on though, what are you filing that's relevant to paragraph 2? Because you said I understood you were going to file some submissions that you sent to Justice Bennett. Maybe I've misunderstood that.
Yes.
And you're going to provide something else.
Affidavit.
Relevant to that, not relevant to the creditor's petition. Do you see what I'm saying? So I'm just trying to focus on paragraph 2.
Yes. So, the affidavit that I filed, that I provided to the court today, which has one correction, the name, but that affidavit lists all the matters on which we rely.
Relevant to paragraph 2. Okay. Relevant to paragraph 2.
Yes. For the notice? Yes. For the amended grounds?